topic that a lot of us have heard about, but what does it actually mean, right? Criminal justice reform is in the eye of the beholder. I mean, Donald Trump will talk about the need for criminal justice reform, right? I think what his idea of criminal justice reform is a little different than what ours is. So I want to start with something that I think should grab everyone's attention. There are 2.2 million people behind bars in the United States. That's a lot of people. And in fact, 25% of the people incarcerated in the world are in the United States. We are only 5% of the population in the world, 25% of the people who are incarcerated in the world are here. Why is that? Well, that's complicated, and I want to spend some time talking to you about that, talking about how that can be reformed and some of the other efforts towards criminal justice reform so we can see where we're at, okay? So first of all, that incarceration rate is a very significant increase from the 1980s when I was growing up, 70s and 80s here, in DuPage County. And there were, I would say, a number of reasons that led to that. One, something called a truth in sentencing law, and we have that federally. So what those laws do is they mandate that 85% of a sentence is served by an inmate. So in the past, what would happen is this, right? A judge would determine a sentence, let's say sentence a particular defendant to 10 years in prison. And then over time, that person would, rehabilitate themselves in prison. They would have job training programs. They would be doing various activities in program that would get them good, I would call as a former federal prosecutor, good time credits. That's how we used to talk about it. And they would reduce their time in prison. Well, what has happened is since the enactment of that federal law, and they also exist in a number of states, although not in Illinois, those have increased the effective time that people spend in prison. Instead of, for example, being able to be paroled for good behavior and only serve half the time, federal prisoners, if you get sentenced 20 years for, let's say, dealing cocaine, you have to serve almost that entire 20 years, 85% of that 20 years, okay? That's the first thing. The second thing is mandatory minimum sentences. So let me explain to you, I want to explain to you how sentencing works so that everyone can understand what that means. So I know a lot of you have heard a lot, I talk on television all the time about potential charges and sentences for people, and you'll hear these things. Paul Manafort's facing a possible 200 and something years in prison, right? We always hear these big totals. The sentences are never anything close to that, right? I forget exactly how many years he got, but it was less than 10 years, a lot less than 10 years, right? That's because there's maximum sentences that are set under law. And then judges consider all these different factors and determine what the appropriate sentence would be. Well, mandatory minimum sentences are a way to reduce the sentencing discretion that judges have so that they have to sentence somebody to a minimum amount of time in prison. And they're particularly significant in the area of narcotics. Narcotics, in the federal system, there are 5-year, 10-year, and even 20-year mandatory minimums for certain types of narcotics crimes, but particularly 5 and 10-year mandatory minimums of a variety of crimes, and they're charged routinely by prosecutors. And I, for example, when I was federal prosecutor, charged people with crimes where they carried with them a 5 or 10-year mandatory minimum. What did that mean? You might have a judge who would see a lot of circumstances about a person and think that an 18-month sentence might suffice, but nonetheless have to sentence them to a 5 or 10-year mandatory minimum because that is what the law requires, okay? So that is driven up federal sentencing. It's also driven up state court sentencing. Here and in other states, there's something called 3-strike laws that also increase sentences. And the idea being that they wanted to put repeat offenders behind bars, but anything that mechanically increases sentences is going to result in judges having less discretion and sentences getting increased. Okay, so I want to kind of throw some of these terms out there, and I want to have a discussion with you about sort of what we could do about it. Another thing, so what have we seen? I would say another thing that in terms of increased incarceration is pretrial detention. And so here's what I mean by that. When we think of sentencing, right, you think of people who are criminally convicted and they get sentenced to a crime at the end. We hear all about that. There are a huge percentage of people who are detained prior to trial. Sometimes that's totally justified for obvious reasons. They represent a danger to the community. people like Jeffrey Epstein before he was killed or killed himself or whatever the truth of that might be. People are kept in pretrial detention, right? Well, we've had reform of that in certain areas. For example, in Illinois and Cook County, massive reform of how pretrial detention is handled. Here in DuPage, we have pretty aggressive use of pretrial detention to detain people because they can't afford a bond. Now, in the federal system, how did detention work? When I was a federal prosecutor, people were typically released on their own recognizance. In other words, they'd have to pay money only if they violated the terms of their bond, but not post money up front, unless they represented some sort of danger to the community, in which case they were detained, or maybe if there was a risk of flight, they would have to put their home or some other amount of property up as collateral or something like that. But it was very individualized, tailored to whether or not a person was at risk of flight. What we've seen a lot, particularly in state court here in DuPage County, we have a state's attorney, a Republican state's attorney here in DuPage County who's been very aggressive about the use of pretrial detention to detain people. And prosecutors use that sometimes to get leverage. And that's the same thing with mandatory minimums and other types of crimes. One thing I want to introduce is a concept that maybe people have heard about, and I think I want to have a discussion a little bit back and forth with you about is prosecutorial discretion. I'm going to put that in quotes, right? Prosecutorial discretion arises from the fact that there's all these laws in the books that can be enforced, and prosecutors are supposed to pick and choose from a wide variety of cases and choose the most culpable individuals to charge, or make charging decisions that reflect good judgment. Unfortunately, that prosecutorial discretion can get abused, right? Racial bias against particular ethnic groups, all sorts of, bias against particular types of individuals, like we're seeing now, for example, the Trump administration. What are they doing? They are skewing prosecution towards misdemeanor immigration offenses, right, at the federal level, instead of prosecuting white-collar crime. When I was a federal prosecutor, we had very small group focused on complex white-collar crime, which was my focus. Much larger group of people focused on narcotics crimes, gang crimes, and things like that. So prosecutorial discretion can also be used when prosecutors have more power to, essentially to leverage defendants. So for example, if prosecutors have the ability to, detain people if they can't post a high enough of a bail, that can potentially lead someone to want to plead guilty. I mean, a lot of times as a prosecutor, it was fairly clear to me that people who were detained had a greater incentive to plead guilty. Higher mandatory minimum can, give prosecutors the discretion if they charge a particular kind of crime, they have a bigger stick to wield over a defendant. And so what I would say is sentencing reform. Why am I focusing on sentencing reform? Because you're going to hear a lot of things, and I'm going to give you an example I'm going to talk about in a moment, the First Step Act, which is this law that the Republicans and Democrats together passed this past year that Van Jones and Jared Kushner and a lot of people were jazzed up about. It doesn't really talk much about sentencing. I'll go through exactly what it does. It doesn't really change any of these fundamentals about sentencing. But in my mind, when I look at the issues here, mass incarceration is the most, to me, the most important, one of the most important components of criminal justice reform. Ending mass incarceration, changing the number and the length of sentences that people are receiving. I think that's very significant. And it's going to take a change in these laws to change, for example, reduction of mandatory minimum sentences, giving more discretion to judges to enable sentences to be lower. Another thing I think that we have that has to be done though is any criminal justice reform changes. Let's say, for example, we have proposals about mandatory minimums or even decriminalization of certain types of crimes. Is you have to think about clemency and looking backward. And here's what I mean. We can have all the criminal justice reform in the world that we want. Let's say your favorite candidate, Democratic candidate, gets elected president, or you get a very progressive state's attorney. That person can change practices going forward. But what about these 2.2 million people who are already in prison? And what you have to have is a governor, for example, or President Obama had an aggressive program, but not, in my opinion, nearly enough, looking at and expanding the use of clemency to deal with this backlog of people who really, in many ways, their imprisonment has an impact not just on themselves, but on their families, on their communities. If you have a parent that's in prison, it can have an impact on their children, for example. It can have an impact that has a ripple effect throughout a community. So that, those are sort of, I'm just kind of introducing some topics, and I hope we'll have a discussion about it regarding sentencing, because I think that's a huge, important reform that we need to have in lowering and kind of dealing with the issue of mass incarceration. And to give you a sense of the First Step Act, and I said Donald Trump and I probably have different views about criminal justice reform. The First Step Act, I mean, I guess it's a first step, but we're talking, here's what it does. Inmates get 54 days of good time instead of 47, per year. They get credits for participating in programs like vocational training. Low and minimum risk prisoners can be moved to pre-release custody, which is good, which is essentially like halfway houses and things like that. I have no problem with that, although I noticed that a lot of these reforms are focused on white collar type prisoners. Creation and expansion of classes for prisoners for reentry, which is important. Putting prisoners within 500 miles of their family. Not shackling pregnant women, which I think is important. A good thing. Reducing the age of elderly release from 65 to 60 and so on. But they're all, I would say, these are tinkering around the edges of the problem, this massive problem that I told you, which is a massive amount of incarceration in this country. So that's, I'm putting that as number one, because I think that's the most important piece of criminal justice reform if we're discussing criminal justice reform. And so that comes with, so to tackle it, to me, there's three things, right? You have bonds, you have to deal with pretrial release, you have to deal with sentencing reform, like mandatory minimums and things like that, and you also have to deal with clemency, looking backward instead of just looking forward. I think kind of something that feeds into this concept of prosecutorial discretion that I talked about a minute ago. How laws are enforced is important, right? And we saw that, we all can kind of, I would say, whether you laugh or whether you hang your head in dismay at how Rudy Giuliani is today, we should all remember that 20 years ago, he was somebody who was leading the charge in this tough on crime, old school Republican idea of broken windows policing. And really, to me, what broken windows policing is it's essentially, it's a nice way of saying, let's not exercise prosecutorial discretion. Let's prosecute people for everything. You get busted a window, or whatever, you steal a candy bar, whatever it is you're doing, let's prosecute that to the fullest, because that's going to have some impact or ripple effect in our communities. The reality is to me, it was a way of focusing on these communities that were disfavored by Republicans, targeting minority communities, for example, instead of focusing on crimes that really matter, which is, violent crimes, human trafficking, exploitation of children, and things that are extraordinarily important crimes that present a real danger to the community in a way that broken window does not. To me, that was a misuse, in my opinion, of prosecutorial resources. So but the problem, I think here's the issue, and I don't have a perfect answer for this, but it's something that I think I'd love to have a conversation with you about, is how do you deal with sort of prosecutors exercising discretion in a bad way? And I think, because look, all of us, no one wants to say that you can never be prosecuted for breaking a window necessarily, but how do you deal with whether it's Rudy Giuliani prosecuting everyone who's breaking a window, or Donald Trump and Bill Barr and Jeff Sessions prosecuting everyone who crosses over the border with a misdemeanor of illegal entry, so that, these are people who are getting like 2 months of time served. And they're spending our tax dollars doing that instead of going after violent crimes or going after white collar criminals. How do you make it so that prosecutors are focusing on the crimes that matter as opposed to ones that don't? That, I think, is a difficult question. And some of these questions, I think, we've talked technology can have a good effect, like, dealing with issues of, for example, here's another Giulianiism, stop and frisk, right? Which is ruled unconstitutional by the courts. But essentially what it was approaching people from disfavored groups. And when I say disfavored, I don't mean disfavored by me or by you, but I mean by the powers that be at the time. It was essentially saying, without any real individualized suspicion And here's what I mean by that. It's totally appropriate. If I have a reason to believe that she has, let's say, an illegal weapon on her, for me if I was a law enforcement officer, to stop her and conduct, what's called a Terry stop, okay. If I've seen her grab a weapon or from an accomplice or something like that, but without anything like that, any particularized suspicion of her, essentially they were conducting just stops on a regular basis of particular groups. That's problematic. So certainly the Constitution sets some sort of floor, but particularly with the changes in the judiciary that we've seen over the last 2 years, that floor is going to be too low to protect our individual liberties. What kind of legislation can we craft that can protect individual liberties? I mean, in the short run, what we can do is we can elect prosecutors who are not going to abuse their power, but that is, to me, a temporary problem. We've got to figure out how to create laws and institutions that are going to ensure that our liberties are protected and the power isn't abused. The other thing that is an important problem that we need to deal with is changing the way that we think of ex-offenders, okay? There's a whole movement called Ban the Box, which is essentially, trying to get the stigma away from employment, thinking about people who are ex-felons as people who have a kind of a mark of shame on them. Because, look, particularly, we have to deal with the consequences of mass incarceration. One of those consequences is there's a lot of people who've been in prison for a long time who need to reintegrate into our society and need to have a second chance at life. And I understand that there's the Jeffrey Dahmers of the world out there, and I get that, but that's not the typical person who's in prison. Typical person in prison is somebody who served their time and needs an opportunity to re-enter into the workforce and become a productive member of society. That's in everyone's interest. So, there have been some efforts made along those roads, but when I think of criminal justice reform, in my mind, those are kind of at the high level, the three pillars. To me, the most important is sentencing, because we have this mass incarceration problem. The second is dealing with how we enforce the laws and doing it in a way that doesn't violate people's rights. And I haven't even gotten to, I was in, I kind of caught up in there. I kind of I'll bracket the issue of police misconduct, because I'd say its own. I could talk for a lot longer about that. I know I only have a certain amount of time, and I want to get to your questions and have a discussion with you. And the third is, how do we deal with the aftermath of the mass incarceration era? One thing I will say, to tie it back to our last speaker, is I do not believe that legalization of cannabis is going to change this problem. And I want to disabase everyone of that notion right now. In other words, that is a problem. There are a lot of people who have been incarcerated for possession of cannabis. And certainly in Illinois, there's going to be some, under the current law, or the new law, there's going to be some reversal of that, right? So there's going to be some justice for those people. But the vast majority of the people in prison in the United States are not for possession of cannabis. There's a lot of other crimes out there. There's a lot of long prison sentences out there for a variety of things. This is a problem that's bigger than that, and this problem is going to remain regardless of whether cannabis is legalized federally. So I'd love to have a conversation. You had a bunch of questions for Representative Cassidy.
Yeah, I've been studying this for a long time myself, and I've been adamant for the last few years that the only reasons to ever put anybody in jail is if they're a physical threat to the community, or if their crimes are not physical, if they're likely to repeat over and over. For instance, the woman who keeps trying to get on airplanes.
Sure.
But I think that our politicians pander to a perception that the public wants long sentences, which I think is insane. Two examples: Bernie Madoff getting 150 years for stealing from rich people. Right. And secondly, Rod Blagojevich getting 14 years. He has to do 85%. For basically, his sentence was for thumbing his nose at the political class and the judicial system. That was his primary reason I think he got the long sentence.
Well, let me address that for a minute, because I think this is something that there may be split opinions about here, and I want to address it head on. I mean, one thing that I have often said, I was a complex white collar prosecutor, and I worked in the office that prosecuted Rod Blagojevich. Okay, I was not one of the prosecutors who sought that sentence, but I was at the office at the time and worked with those prosecutors, and they're I wouldn't say friends of mine, but I know them very well and I'm friendly with them. I guess what I'd say is a couple things. I mean, first of all, I do believe that sentences are disparate those sentences are actually stand out because they're outliers. And that in my experience, and I prosecuted a wide variety of crimes over a decade, and I've seen lots of other crimes prosecuted and been exposed to them. Now I represent people who are investigated and prosecuted, that people who look like me get lesser sentences on average. And people who are professionals and people who can have money and can afford people like me to represent them, get lower sentences. And I will say, I actually think that the sentence of somebody who is, let's say, like when I prosecuted the first high-frequency trading case, that one case, that one sentence, 3 years for that one man, had a ripple effect in that entire industry that I think is greater than that one sentence, in a way that prosecuting one more person for dealing drugs in Inglewood doesn't. And so I do think that having prosecution of white-collar crimes can have a positive impact. But I agree that sentences across the board are high, and they're too high. And I don't think that putting Bernie Madoff in prison for 150 years solves all society's problems, or solves the problems of his victims, right? He suffered and he lost, I don't know whether it's $1 billion or hundreds of millions or whatever, they lost a lot of money. I guess what I would say though, when I think about the problems of criminal justice reform, if I had a magic wand, which unfortunately I don't, but I would be thinking about large drug sentences, for particularly, from federal drug sentences over, from the 80s, 90s, 2000s as the first place I'd start, because there's a lot of people who distributed X quantities of cocaine, who aren't inherently dangerous, who are spending 10, 20, 25 more years in prison. And I don't see the benefit of society for that. Yeah.
So back to prosecutorial discretion. So to me, as an average citizen, I would like to know how we can hold prosecutors accountable, because they make their decisions on using, their resources, their tools, their education, their experience. There's a huge debate about, using AI to, make determinations about sentences. How can we infuse accountability into the picture?
That's a really smart question and a difficult one. Okay, one thing I want to say just before I get to that question, because I think it's sort of is a precursor to it, is I don't think prosecutorial discretion can ever be completely eliminated from the system. As long as there's limited resources, I don't know if we want prosecutors prosecuting every case they possibly could, and I think they're always going to have limited resources. So unfortunately, they're always going to have some judgments made. And I would say currently, it's very hard to hold prosecutors accountable other than at the ballot box, right? You can vote Bob Berlin out, people in Cook County can vote out Kim Foxx if they don't like her. But federal prosecutors can't be voted out. I mean, you can vote out the president, but no one votes for president based on their choice of prosecutor. Very few people do, right? I mean, you're not choosing, your vote against Donald Trump has nothing to do with his appointment of John Lausch as head U.S. attorney in this area, right? It's bigger issues than that. To me, the most important thing is transparency. And the problem that's inherent with that is this. A lot of times prosecutors are scrutinized for not prosecuting certain people, right? For example, all of us in this room have questions about why there was not an increased investigation of the Trump Organization, for example, in the Southern District of New York. Why was that cut off? Well, one reason the Justice Department might give that's legitimate for not telling us and explaining that is that when an investigation is halted and no one is charged, those people have rights who are being investigated, and it's not appropriate to tell the public and discuss, the backgrounds of people who haven't been charged, because the public should not be hearing about allegations that can't be proven in a court of law, right? And so it's not the job of the Justice Department to spread rumors that they weren't able to prove in court, or allegations that they couldn't prove in court. so the non-charges, I think, can be difficult. And those, we can judge those people at the ballot box, but I think that's one of the reasons why I think it's difficult to have laws about whether, you're not charging something enough. I do think, however, that we should have better sort of transparency around charging decisions that were bad. Because when a charging decision was made and results in, for example, a not guilty verdict, right? If there's a not guilty verdict, why was that case charged in the beginning? I mean, it's not necessarily, sometimes it can be that things went awry at trial for a variety of reasons. I mean, for example, R. Kelly was found not guilty. Now there's a new indictment, federal indictment, that suggested that he paid off witnesses and so forth. I don't know whether that's true or not, but my point is the mere fact of not guilty doesn't necessarily mean something, but I think having greater transparency and perhaps some sort of review after the fact, some body, like we have police review board, why don't we have prosecutorial review that's reviewing why prosecutors are making charging decisions that seem questionable, whether or not, even if, for example, if there's a guilty verdict. Now, I will say if there's a guilty verdict, there can be review through a judicial process, where prisoners have a habeas process that they can undertake that can sometimes result in review. But when there's a not guilty verdict or the charges later get dropped, there isn't. To me, that would be one way in which you could also have, I think, we don't have the fact that we don't have a review process, is exasperated. You see there's, for example, a recent case of Justice Smollett. Before that, there is, all these issues regarding Laquan McDonald and why there's non-action there. You could imagine a more aggressive process that was overseeing the prosecutors that could have, I'd say, a role in informing the public when there's non-decisions or decisions that are resulting badly being made.
Yeah. Along these lines, what's the relationship between prosecutorial discretion and plea bargaining? Now, is there an incentive to threaten, especially a relatively resource-poor defendant with, 20 years in prison if you plead? And isn't there a risk to society as a whole that you're going to end up getting confessions or getting pleas from people who may not be guilty after all?
I think it's a great question. It's a challenging one, because, in the ideal scenario, right? I mean, here, I'm gonna talk to you about it in sort of, I'll say, how the system ordinarily works or should work, and then how it gets abused. Because even in how the system ordinarily works, there's a coerciveness in the process, right? So the way the system works, like when I was a federal prosecutor here in Chicago, we were careful. They were very, I would say here in Chicago, pretty cautious office. We charged cases we could prove. We very rarely lost cases. But I think it's fair to say, particularly in cases where they thought they would have some challenge in getting a conviction because it would be a well-financed defendant or something else, they would charge all these charges in a case. For example, the Blagojevich case, you use an example. There's a lot thrown at Rod Blagojevich. Now, I believe he was guilty of a crime, and we can disagree about that. Yeah, okay, but a lot was thrown at him, partly to make it hard to not find him guilty on something, okay? And that's something prosecutors do. They throw all these counts at somebody, knowing that that's gonna make it hard. Their lawyer can then look at them and say, well, if we plead to one count, you're a convicted felon, and that's, you're going to prison, and this and that. But, that's a better result than being found guilty of 12 or 19, or, I think, Pat Cullerton, was it Pat Cullerton? What's his name? Tom Cullerton. Thank you. So many. Okay. Tom Cullerton was recently charged like 40 counts, 41 counts. I mean, it's like, well, sure. I mean, it's hard for a jury to check not guilty 40 times or whatever it is, right? So that's just but even, my point is, even that has its own element of coercion in it. The problem is, like you said, there are times, there are some prosecutorial offices, I'm not gonna name names, okay, but there's some prosecutorial offices that are, just charging things without having, I'd say, an appropriate level of review. Sometimes they can't prove their case, but there's enough there, And a person, you know, it's very expensive to hire lawyers, you know, and, certainly when people hire me now, I mean, it is a huge part of the equation. And an unspoken part of it is that regardless, even if they're never charged, or even if for example, I tried a case this year of a Naperville man who was accused of a crime and he was not guilty. Okay, you know, he was acquitted, the judge acquitted him and said no rational jury could find him guilty. Well, he still had to pay me a lot of money. My law firm, I wish it was me instead, or you know, I would have given him a break, but my law firm a lot of money for that privilege, right? And so, yeah, I think it's a problem. It results in it results in injustice potentially being done, but it results in disparate results, because you could have a well-funded defendant versus a not well-funded defendant. I would also just say the incentives that creates are bad too. In other words, if a prosecutor knows they're facing a very well-funded defendant who will be very aggressive, then they've got to put way more work in the front end to prove that case, and they're going to put way more work into getting that conviction. It can create disincentives to go after those type of defendants.
Well, can judges be more vigorous in reviewing plea bargains?
It's a great question, because judges are vigorous so the way that judges review plea bargains now is very vigorous in a different sense than you're getting at. In other words, it's very vigorous about making sure that the person's informed of their rights, knows that they can't go to trial. Well, you'd be surprised, you sit there for an hour and the judge asks him 100 questions about, are you sure you know that you can get that you could select a jury? Are you sure you know that you can go to trial or whatever? All these things. But it's not on making sure that, and some judges do ask, in your own words, what did you do? And things like that. There is some of that I've seen, but, particularly I will say, I'd say our system is overburdened. I mean, part of, I think, dealing with that first problem will help dealing with the second, particularly in the state system. It is very much a process that is going very quickly because judges have pretty busy dockets. I don't think, from what I've seen, judges aren't exercising the level of discretion that they might, but I will tell you, even there, judges often don't want to get into, the behind the scenes of what that would be. And one thing that is happening a lot, I will say, in the state system that does not happen in the federal system, is judges essentially saying, like, look, if you plead guilty, this is the sentence I'd give you. If you go to trial and you're found guilty, this is the sentence I'd give you. And so the judge almost participating in a way in the plea bargain process, whether that's, for some defense attorneys like that, but you can understand that the incentives are the judge is baked into the incentivization process, yeah.
Well, a big thing that I think you alluded to is that the courts are so overburdened. If we didn't have plea bargaining the way things are now, then it would be years and years before you could get a trial.
Absolutely.
So that is an advantage. That's a reason for having the plea bargain. Another aspect of this is the lack of judicial discretion, judicial discretion in many cases where there are mandatory sentences, because if the choice of the defendant is plea bargain or take a risk on something that carries a 20-year mandatory sentence, that is such an enormous risk that there's a big temptation, guilty or not, to go for the lower one. And of course, this is something that DAs are going to use.
I think that's right. I mean, another thing is what prosecutors have is charging discretion, how they charge a crime. So, one thing that I will tell you is one of the things that actually had a significant impact on lowering incarceration during the Obama years, and I was a federal prosecutor during almost his entire presidency, was they made a decision to exercise their discretion not to seek mandatory minimums. So you had to make certain allegations, factual allegations, in order to get a mandatory minimum, like this offense involved X quantity of heroin or something. And they would not make those allegations in certain circumstances unless the person was affiliated with a gang or violent crimes or this and that, so that this way, they were exercising their discretion appropriately to reduce sentences when they weren't necessary. But I think prosecutors can pick and choose. The fact they can pick or choose statutes can give them the power to, offer the defense essentially a choice between having, it gives a lot of hammer to the prosecutor in the negotiation. Yeah.
There's a really excellent book that you probably are familiar with by Emily Bassel and called Charge, that deals with a lot of these same questions and goes into examples and what different states have tried.
I am familiar with the book. I will say, part of it, and I think you're approaching it this way in terms of how the system works, because you clearly have read something about the subject, is one of the things that I think people who are not familiar with the system, haven't experienced it, don't understand is, like you said, there's such a volume. The system, the way it's built with the amount of resources we put in it, would not work if the process had, if you had to go through the full process. If I represented every criminal defendant in the United States and we were fighting to go through trial on every case, the system could not exist as it is today. The system exists as it does today because of plea bargaining, because of people confess to crimes, because there are certain types of offenses for which the evidence can be so overwhelming that there's no point. I mean, all of these crimes that the Trump administration is charging now, there's no defense. I mean, you're caught here. You could put an exhibit sticker on the person, their hair. So there's no trial that would ever be possible on those sort of, there's no defense. What's similar, there's other types of crimes, like whatever. You're caught with 100 kilos of cocaine in your car. Like, it is what it is. It's the argument that you didn't know was there is generally untenable. Or you're caught in the bank with a gun. So, but there are, I think the question is, I think, how many resources do we want to devote to law enforcement? What types of crimes do we really want prosecuted? And what types of sentences do we want? And people don't answer these questions. And politicians, the way it's worked for so many years is that what we prosecute now is always a floor. It can only go up. It's sort of like when I was a federal prosecutor, one thing that was a truism that everyone understood was that the number of FBI agents focused on anti-terrorism work would never go down. It kept increasing over time, but it would never go down, because if you were the guy who reduced the amount of agents working on terrorism, and there happened to be, could be totally coincidental, a terrorist attack within X number of months, years later, they would blame it on that reduction. And so, it always goes up. And similarly, I think politicians, it's the simple thing to do is just keep ratcheting up sentences. But as a society, we pay a price, and those people who are imprisoned pay a lot higher price, unfortunately. Sure. Unless somebody else does, I'm going to give everyone an opportunity, but yeah.
Well, one suggestion that seemed like a really good reform that would not be that hard to implement at different levels is to have alternatives to jail time.
Yeah.
It's for nonviolent crimes, especially drug possession or gun possession, to have a sentence that involves some sort of rehabilitation program, community service, or something like that, because the prisons do not reform people.
I think
programs can.
I think it's fair to say that there aren't enough alternatives to imprisonment. Do either of you have a question? I saw one you have, yeah.
We're an activist group, and one of the things that I see happening in DuPage County is the bail bonds issue. What would you suggest would be a method of kind of forcing the issue from an activist perspective?
I think that the current state's attorney is very concerned about keeping his job. He's up for re-election this year. And so, in addition to ideally having a candidate who runs on that issue, I would think putting pressure on him to change his practices on that issue. But you have to be watchful of it. I've talked to some defense attorneys about it. One thing they're concerned about is that Republican state's attorneys might say, oh yeah, we're not going to have high cash bond requirements, but then they'll just seek to incarcerate more people, and say that they're a danger and they should be held without detention. So they're worried about that. When I talk to defense attorneys, their clients getting a worse result. I think what we have to do is to push for, not that I understand that we may not be able to achieve everything that was achieved in Cook County in terms of having the massive change that there was there, but there's no reason to be seeking, cash bond in the vast majority of cases. When I was a federal prosecutor, we saw cash bond in a very small minority of cases. You either saw the person detained because they were in danger, they did something very violent, that's understandable, or because they're a flight risk. And then there's a flight risk where that might be at the point where there's a real flight risk. Like, this isn't somebody, You know, it's not like somebody who lives in Lombard and has lived in Lombard their whole life, but like somebody who's an international financier and flies around the world. Okay, you know, maybe Lev Parnas or whatever that guy's name is, you know, should have to have a bond. And then the rest of the people just are on their own recognizance. That's how it usually worked for nonviolent offenses. They would just sign a sheet of paper and they would be out the same day. In the federal system, I don't see any reason why that can't work here. Yeah.
Are you concerned at all that as a society, we might be, I'm not saying we are, but we might be overcharging policemen who kill citizens through stupidity or negligence? In other words, charging with murder instead of voluntary manslaughter, which to me, there's a big difference. To me, murder is where you, for a malicious reason, want to kill somebody.
It's a good question. So usually there's concepts called lesser included offenses. So for example, in the Van Dyke case, right, the Laquan McDonald case that everyone, well, probably everyone in the room is familiar with, you know, he was found guilty of, I think, 2nd-degree murder and of aggravated, was it aggravated battery, I think, or
Yeah.
something like that, right? And ag-bat was actually the more serious of the two crimes. The 2nd-degree murder sounds worse to lay people, but under Illinois law, it's actually the lesser serious crime. But he was charged with 1st-degree murder, and so the court, juries have the ability, if a prosecutor thinks the facts warrant it, to ask for a lesser included offense. The issue there is an issue of proof. And one thing as a prosecutor is I would never offer a lesser included offense or a lesser offense if I believed that wasn't really what happened. In other words, if I believe that the person really did plan to do something, I would not offer something that was counterfactual to the jury, because I didn't want, first of all, I thought it was my job to tell the truth to the jury, and I didn't want the jury to find something that was false, or to prevent. I thought it was inconsistent with my role to be offering something that was false. So I don't know if, to me, what I see is that police are usually undercharged, and partly it's because of, I would say, for 2 reasons. One is grand juries don't even like charging cops, so sometimes you're getting stuff presented to grand juries and they don't return indictments. Second of all, police can be difficult to convict, period. There's always some reasonable doubt. You need to get 12 people to go to unanimously convict. I understand it may seem like, oh yeah, prosecutors always get convictions. It's because they pick and choose their cases, and they usually choose easy cases, slam dunks. They don't choose the hard cases, which, by the way, is a big reason why they don't go after white collar crime as much. Because those cases are harder to prove by their nature, and I can explain why if you don't, that doesn't seem intuitive to you. And the people are more well-funded and more aggressive. Yeah.
Because I had a conversation with Berlin not too long ago, and when he does not really believe that there's any racial bias in DuPage County in his office. And, well, you were at the same event I was, so.
I am.
Yeah, I mean, it was like, you know, he just absolutely is so, I don't know the right word. But how do you go about helping him shift his mind or his belief system?
Yeah, it's interesting. I think if I had to characterize Bob Berlin's views, it's like he's like somebody who came, you know, it's like Back to the Future. It's like if we went back from 1985, when I think Back to the Future was filmed, and brought a prosecutor from back then to today. I think those attitudes towards prosecution, he kind of carries with him those attitudes. In other words, we're colorblind, and that's somehow. I mean, I heard it. He said before the meeting that we were both at, you know, he said publicly, when talking about a case where there was an officer who had you know, involved in a shooting, he had said that there's no racism in criminal justice in DuPage County, which in my mind is an inappropriate thing for a prosecutor to say, even if he believed it, because he is the person who's going to have to evaluate future cases of potential criminal activity by law enforcement in DuPage County. So how could he prejudge the case effectively of every potential police officer if he could even get into their mind? But look, to me, if I had to convince him, and I convince juries and things, that I think he'd be a hard person to convince, but I would try to present statistics. You know, I think when you look at the types of people and the types of crimes that they actually prosecute, I mean, is he going after white collar crime in DuPage County? I mean, let's just be real here. There's a lot more white collar folks here than there are blue collar people in DuPage County. Is he going after that type of crime? You know, what types of people is he actually prosecuting, and what sentences is he seeking? And to me, when I look at the types of crimes he prosecutes and the sentences he achieves, it looks a lot more like a prosecutorial office from 1985. And the reason I say that, and it's not a euphemism, I'm saying that the problems that I talked about at the very beginning were because of the policies that we had in the 1980s and 90s that have carried forward and created a mass incarceration problem. And I see that here, very old school. He jokes, and tells people around the state that, he is he's the lead prosecutor. He views Kim Fox. Cook County's not a real prosecutor, she's a defense attorney. He's the lead real prosecutor in Illinois. And I think in his mind, a prosecutor is somebody who sort of goes after convictions and jails people. I am a tough on crime person myself in a certain sense, that I think that there are certain types of crimes that have an impact on society that are under prosecuted. Things like white collar crime and corruption. As I said, I might have a disagreement with certain people. I think we should be investigating that type of crime more than we do. But just incarcerating people the maximum amount is not the way to do it.
Can I ask just another question too? 'Cause,
Sure.
I mean, this is, what Tom Dart did at Cook County. Is there
Sure.
any lessons or anything I'd love to implement what he did, but is there anything from his work to try to do something in DuPage?
I think the biggest thing that we can do is talk about how, if you look at the crime rate in Chicago, look, I was involved, I was a federal prosecutor from 2007 to 2016, so basically 10 years. And, I've been a resident since then. It's not like violent crime has jumped off the charts since they've made bail reform, right? It hasn't had any spike in crime. What we hear about, it's like kind of how we just heard a moment ago from the representative about how there's gonna be this, people are gonna realize the world doesn't change when cannabis is legalized in Illinois. We've already seen what would happen in a world with bail reform. A much bigger county right next to DuPage has had reform, and nothing's changed other than the fact that a bunch of fathers got to be with their daughters, for example, and that's a good thing. Like, we want people to be able to have another breadwinner in the house, or a parent to be with their child. Like, it just, in terms of, if I was talking to Bob or someone like him, I'd be like, or somebody who's hard to convince, I'd be like, let's think about what the effect this has on a family or on a community. And I think that can't be overstated. You take a parent away from their child, that can have an effect on the child for the rest of their lives. Sometimes it's necessary to protect the public from future crimes of that person, fine. But we put those cases aside, but there's plenty of cases where somebody is, whatever, you're engaged in theft. Clearly wrong, I'm not saying people should steal, but it doesn't necessarily mean that we should be putting the person in prison before they've had an opportunity for trial. Anything else? What I would just say to all of you is I want to have a real discussion with you, and I really appreciate you guys having that on this. I think it's a complicated topic, not like a simple tagline, and I hope that we can kind of work towards making some improvements on this, as opposed to it just being something we talk about. Thanks a lot.
Thank you so much for coming.
Real pleasure.
Okay, so that's the end of our meeting, and I just want to highlight a few things as people are about to go. Is that we have a Thanksgiving, sorry, there's a space in between, type of event, and we have all the details in the flyer as you walk out. And it's being organized by Erica, and basically we're trying to make sure that the elected officials all have a whole lot of charities and places that they've been dealing with, and so we're gonna highlight like what Sean Texton or what Tara Costa Howard really are impressed with. Both Renato and Representative Kelly Cassidy's speeches are gonna be on our YouTube channel. So if you wanna let other people know about it, they are very informative and very helpful, so we can spread those along. And we'll try to put those on our website. And then the other thing is right now there's a lot of people getting ready to run for office. This is petition season, our favorite. And so right here, as you walk out, there's a variety of different petitions that are set up. So please walk through and, please sign some of them. Thank you very much, and we'll see you next time.
We tried.